Character. What's our general rule? That's right, FRE 404. Evidence of a person's character is inadmissible to prove that on a particular occasion, the person acted in accordance with that character or trait. FRE 404. Evidence of a person's character or character trait is inadmissible to prove that on a particular occasion, the person acted in accordance with that character or trait. Okay, repeat the whole rule. FRE 404. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion, the person acted in accordance with that character or trait. Okay, let's talk through the exceptions. First of all, let's talk about the criminal exceptions. A criminal defendant may open the door. A criminal defendant may, that's right, introduce evidence of the defendant's pertinent trait. And if so, the prosecution may offer evidence to rebut it. What kind of evidence are we talking about? Of course, we're talking about reputation or opinion. So all our criminal exceptions, the criminal defendant may open the door with reputation, opinion evidence of the defendant's pertinent trait. They must open the door. And if so, the prosecution may offer evidence to rebut it in the form of reputation or opinion. On cross, the prosecution can examine the witness, ask questions about the defendant's character, truthfulness or peacefulness, and they may rebut it with what? Specific instances of conduct. Remember, that's only on cross. On cross, the prosecution can do what? Ask the character witness questions about veracity or peacefulness. And if the witness denies it, they can say, hey, did you know that so-and-so was convicted of battery last year? You cannot use, that's right, extrinsic evidence. Cannot use extrinsic evidence. Okay, so our rule is, 1, the criminal defendant may open the door by introducing evidence of the defendant's own pertinent trait. If so, the prosecution may offer evidence to rebut that in the form of reputation or opinion. What happens on cross? The prosecution can examine that defendant witness, and if they say, hey, he's a peaceful guy, they can rebut it with, didn't you know that, isn't it true that the defendant did this or that? But they are stuck with the answer. No extrinsic to prove. Okay, rule number 2 for a criminal defendant. The criminal defendant may offer evidence of the victim's pertinent trait. And the prosecutor may offer evidence to rebut it and offer evidence of the accused's same trait, reputation or opinion. Criminal defendant, what are you doing? You are offering evidence of the victim's pertinent trait. Hey, he's a violent guy. So the prosecutor may then, on cross, give evidence to rebut it, reputation or opinion, and offer reputation or opinion evidence of the defendant's same trait. Okay, let's simplify that. A criminal defendant may offer evidence of his own pertinent trait, and if so, the prosecution may offer evidence on cross to rebut it. No extrinsic evidence to prove it. The criminal defendant may offer evidence of the victim's pertinent trait, and if so, the prosecution may offer evidence to rebut it and offer evidence of the defendant's same trait. Finally, we've got our homicide rule. In a homicide case, the defendant may offer evidence of their own trace of trait. Remember, the defendant opens the door. If the defendant offers evidence of their own trait of peacefulness, remember, this is only homicide, the prosecutor may offer evidence of the victim's trait of peacefulness to rebut evidence that the victim was the first aggressor. Okay, you killed somebody. You say, I would never kill someone. I'm a peaceful guy. The prosecution may rebut by offering evidence that the victim had a trait of peacefulness to rebut evidence that the victim was the first aggressor. Remember, in a homicide case, we're always rebutting evidence that the victim was the first aggressor. Okay, 1, criminal defendant may open the door, offering evidence of their own pertinent trait. If so, prosecution may offer evidence to rebut. Reputation or opinion, no extrinsic. Criminal defendant offers victim's pertinent trait. Prosecution may offer evidence to rebut and offer evidence of the defendant's same trait. Homicide. Prosecution may offer evidence. Defendant opens the door by offering evidence that they would never kill anybody. And the prosecution may offer evidence that the victim's trait, the victim was a peaceful person, to rebut what? That's right, evidence that the victim was the first aggressor. Okay, next exception, when character is the ultimate issue. Ultimate issue. When is character the ultimate issue? 3 things: defamation, negligent entrustment, fraud, or representation. Character is only the ultimate issue in defamation, negligent entrustment, fraud, or misrepresentation. If character is the ultimate issue, can you offer extrinsic evidence? Yes, because it is an element of the charged offense. So you can offer reputation, opinion, specific instances of conduct. If character is the ultimate issue, the defendant may offer reputation and opinion evidence and extrinsic evidence. Okay, other bad acts that didn't result in a conviction. Okay, what do we need to do first? Prosecution, notify in writing before trial. Okay, other bad acts. Are they admissible to prove that in a particular occasion that person acted in accordance with that character? No. They're admissible for the mimic cop exceptions. The prosecution is always going to argue that this isn't a character argument. Rather, they will offer it to prove 1, motive, 2, opportunity, 3, intent, 4, preparation, 5, plan, 6, knowledge, 7, identity, 8, absence of mistake, 9, lack of accident. Inadmissible to prove character and conformity, admissible to show motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, lack of accident. These are 9. There are 9. Motive, 1. 2, opportunity. 3, intent. 4, preparation. 5, common plan. 6, knowledge. 7, identity. 8, absence of mistake. 4, lack of accident. Okay, so that's our other bad acts. Do you have other bad acts or stuff that doesn't result in a conviction? Okay, let's talk habit. Any party can offer habit or routine practice evidence. Nobody needs to open the door. Any party can offer evidence of a habit or routine practice. You don't need to open the door. Nobody needs to open the door. Either side can offer evidence of habit or routine practice. And it may be admitted to prove that the person or the entity acted in accordance with that habit or routine practice. Evidence of a habit or routine practice may be admitted to do what? To prove that on that occasion, the person or organization acted in accordance with that habit or routine practice. Do we need corroborating evidence? No. Do we need extrinsic evidence? No. Do we need some sort of witness? No. For it's easy to get habit or routine practice evidence in. It may be admitted to prove what? That's right, the person or organization acted in accordance with that habit or routine practice. Okay, prior accident, usually excluded unless you can prove the defendant was aware of a dangerous condition. Prior accidents are usually excluded unless you can prove the defendant was aware of a dangerous condition. Okay, moving on to other convictions. Other convictions. Remember, character and conformity is always inadmissible, but other convictions may be admissible to impeach. Other convictions may be used to impeach. Crimen falsi, we know this. The judge has no discretion and they must admit crimen falsi. Okay, let's talk about other felonies. More than 10 years old from date of conviction or release, we're going to have notice and a hearing. What if they're less than 10 years old? Other felonies less than 10 years old from date of conviction or release, whichever is later, are admissible. Okay, here's where we get into the witness who's a defendant or the witness who is a defendant. Okay, if the witness isn't the defendant, probative value has to outweigh prejudice. If it's the defendant, the prosecution must show the probative value outweighs prejudicial effect to that defendant. The witness isn't defendant, probative value must, that's right, outweigh prejudice. If we've got a criminal defendant witness, prosecution must show what? Probative value outweighs prejudice to whom? That defendant. Okay, do we need to give the AP reasonable notice in writing? Yes, and if we're going to offer a criminal conviction that is more than 10 years old, what do we need? Oh yes, Montgomery motion and a hearing. Okay, when can we admit a juvenile adjudication? Never in a civil case. What about a criminal case? Can we admit a juvenile adjudication in a civil case? No. Can we admit a juvenile adjudication in a criminal case? Maybe. Only when it's necessary to fairly determine the defendant's guilt or innocence. Repeat, juvenile adjudication civil case? No. Juvenile adjudication's criminal case? Only when necessary to fairly determine the defendant's guilt or innocence, and that is character.